Okay, so we left in that article 21A, free and compulsory primary education. Do you remember for whom free and compulsory primary education is given? What is the age group?
Ma'am, 5 to 14 years.
6 to 14 years. Okay, if you get confused, you can simply consider in which year you will be in class 1. Usually 6 years only, right? So from class 1 to 14 years, it is given. Okay, from class 1. So it is 6 to 14 years. Okay, so next article that we have is Article 22, which talks about protection against arrest and detention in certain cases. That means might be a case is filed against the person, okay, and the person is arrested or the person is detained, as in it might happen that case is not finally decided, okay, because we have seen another one, right? Protection from conviction of offenses. Someone whose guilt is proved, court has decided that yes, he is guilty, give him punishment. That's a different matter, but this is what? This is a person is arrested or detained. Might be his case is not yet been finally decided or something. In that case also it will be included. Okay, when we say arrested or detained, it may happen that an FIR is being filed against a person and he is arrested by the police officers, right? Or might be preventive detention. Are you aware what is preventive detention? Have you heard of it? Preventive detention, anything?
Ma'am, I have heard, but I don't know meaning, ma'am. I have heard this meaning, that preventive detention.
You have heard, right? What is detention? Detention is like keeping someone somewhere. Okay, let's see what is the literal meaning of detention. Okay, detention means the action of detaining someone, the state of being detained in official custody. It is a process whereby state or private citizens are hold a person by removing their. See, this is what it is. Your freedom is taken. Okay, someone's freedom is taken or liberty is taken. How can your freedom be taken? It again indicates that okay, fine, a person is arrested. Okay, detention in simple words we can say a person is arrested. All right, now what is the difference between arrest and detention? When we talk about arrest, right, it mostly happens that an FIR is being filed against that person, or might be a case is registered against the person and his trial is pending. Court is deciding whether he is guilty or not. That time, if he is kept in prison, right, it is called as arrest. But what is preventive detention? It is basically that person has not even committed a crime, but there is a possibility that he may commit a crime. Okay, it is preventive detention. That means he is detained. He is kept in prison in order to prevent him from committing a crime. We don't want him, or we don't want to give him that chance of committing a crime. So before only we are arresting that person. So there are some legislations which we call as preventive detention legislations, okay, under which a person may be arrested even before committing a crime. They're like Armed Forces Special Powers Act is also preventive detention. Okay, like that we have laws whereby a person may be arrested even before committing a crime so that he can be prevented from committing it. Okay, so this particular Article 22 provides protection from these two situations, when a person is arrested or when a person is detained in certain cases. Okay, again, this right is applicable both for citizens as well as non-citizens, because it's very important. Even of, yeah.
Detention meaning what, ma'am?
Detention is like keeping someone in custody. Okay, in simple words, here it basically means keeping someone in prison, sending a person to jail. Okay, arrest is also same, sending a person in jail, but might be here an FIR is filed against the person or a case is registered. But here, no FIR, no case. Simply the police officer or might be armed forces, they are suspecting that this person might commit something wrong. This person may commit a crime. Based on that suspicion only he is arrested. Okay, is it clear? Difference?
Yes, ma'am.
So in
Then
both the
prevention,
cases,
ma'am.
yeah, preventive detention, like to prevent him from committing a crime. Okay, the person is arrested.
Okay.
Okay, so both arrest and detention, both the cases, it is applicable. And this right is applicable to both citizens as well as non-citizens, because even against the foreigner, there might be a case. To them also, it would be applicable. No person who is arrested shall be detained in custody without being informed as soon as may be the grounds for such arrest, nor shall he be denied right to consult and be defended by a legal practitioner of his choice. When a person is arrested, the moment he is arrested, as soon as possible, he should be informed why is he even being arrested. Is there an FIR filed against him? If yes, what are the charges, right? What is it that he has done, right? What wrong has he done? Why is he being arrested? That as soon as possible, he should be informed. Okay, it should not happen that the person is arrested, he is kept in the custody, he is not informed anything, he is simply there for months together. That should not happen. Okay, you can arrest the person. The moment you are arresting, inform him why he is being arrested. Also tell him that you have a right to consult and be defended by a legal practitioner. You can hire an advocate. You can tell him the situation, that this is what has happened, an FIR is filed against me. What should I do? Help me to defend myself. Right? That thing should be informed, because some people might not be knowing this, right? That if I am being arrested, I have a right to consult a lawyer. Some people might not be knowing that, so they should be informed about it, and they should be allowed that, okay, fine, you can talk to your lawyer, you can consult him, your lawyer can defend, and all that should be given. This is the first right which they are having, or first kind of protection that we have. Okay.
Yes, ma'am.
Secondly, it said when a person is arrested, fine, an FIR is being filed, the person is arrested. Okay, now why is a person arrested? What do you think? Why a person is arrested when an FIR is being filed?
If he did any crime or if he doing anything wrong.
But
like
court
that,
is
then
there
he's
to
arrested.
decide that, right? Whether he has done a wrong or not, court will decide it. FIR is just letting the police know that this has happened. Why is he arrested based on the FIR only?
Ma'am, that is the police duty, that he has to take the first information from what he did wrong, and the police has to give the information to the court. No, so his duty that he has to give the information of what the wrongs he did in the court.
Yes. So if I'm going to the police officer and I'm, asking them to write an FIR, I would simply give the details that this is what has happened. So and so person has committed the crime, right? But then police officer, like you said, correct, police officer will have to inform the court that this is what has happened. This kind of an FIR is being registered. And after that, police officer need to do preliminary investigation, like we see in movies, right? Police officer would go to the murder scene, they would take the gun and all those stuffs in, like Ziploc bags as an evidence. They would take everything. So these are nothing but they are doing the preliminary investigation. They would talk to the witnesses and someone who is available, right? So when a person is arrested, it is because police officer wants to do preliminary investigation. There, police officer would need to gather some information from the person also. So it's very important that police officer is allowed to arrest that particular person, so that he is there in their custody, right? In the station, police station itself, we see, right, some custody would be there, some lockups would be there, they would be kept there, so that police officer can easily communicate with them. But police officer is not having their entire lifetime to do the investigation. Within 24 hours, they should be completing the investigation. Okay, within 24 hours, sometimes it might not be possible. So within 24 hours from the time of arrest, they should be produced to nearest magistrate. And there, if police officer feels that, okay, our investigation is not done, maybe we need this person to remain in custody for 5 more days. So police officer would request the magistrate that we need some more time. In such a case, magistrate can send them to judicial custody. That, okay, fine, we are sending him to judicial custody, we are sending him to prison for 4 more days. Within that time, you do complete your investigation, right? This is what will happen in that particular case. So presenting before magistrate within 24 hours is the second kind of protection which has been given. Okay.
Yes, ma'am.
Now, thirdly, fine, we have provisions relating to preventive detention. Even before committing a crime, the person may be arrested. But preventive detention, it should not happen that the person is arrested and he is kept in prison for years and years together. Okay, there are a lot many rules and regulations which are applicable. Like for 3 months, he can be arrested. After that, some approvals need to be taken. Only if approval is granted, then only he can be kept in custody. Okay, all those things will happen. So mainly these two parts are important. And thirdly, for preventive detention, you can mention that for there also we need to follow lot many rules and regulations. It should not happen that simply they are, you know, like arresting the person and keeping them in custody. So these are the 3 rights which are guaranteed by way of Article 22, protection against arrest and detention in certain cases. Okay, is it clear?
Yes, ma'am.
Now, fine, these rights are given, but is it enough that we just have 3 rights? There are so many custodial violence that takes place, right? People are taken in custody and then police officer starts beating them, starts torturing them. So many situations happen, right? So it was realized that it is not enough. Okay, it is not enough that simply these 3 rights we are having, and based on that we are expecting that the person will enjoy his rights and stuff. Okay, there is this very famous case, DK Basu versus State of West Bengal. It is a case of 1996. It's a very important case. You can read about it. Okay, what happened in this case is there was a, like NGOs would be there, right? Like that, there was one body which is Legal Aid Services. This was in West Bengal. Okay, there was one organization, Legal Aid Services in West Bengal, and this person, DK Basu, was the executive chairman of this organization. Okay, one day what happened is he was reading some newspaper articles and he saw that there are too many custodial violence taking place. Okay, in custody a person would be taken and the person ends up dying there because the police officers was beating him, or maybe so many other different tortures. All right, so what he did is he wrote a letter to Chief Justice of India. Okay, Chief Justice of India of Supreme Court, he wrote a letter and he informed that there are these articles published in Telegraph newspaper. Okay, that in police lockup, there are a lot many tortures that's happening. So these, matters he highlighted and he wrote a letter and he said that whatever letter I'm writing, right, you should consider it as a writ petition. You should consider it as a public interest litigation. In the interest of general public, I want to bring this matter in notice of the court. You can consider it as a public interest litigation and you can proceed with the matter. Okay, Supreme Court read the letter, Chief Justice of India read the letter, and Chief Justice of India also felt that yes, this is actually a very serious matter. Actually, a lot many deaths are taking place in custody. In custody, tortures are taking place. So we need to do something. Only Article 22 is not enough, which is providing only for 3 different rights. Okay, it is not enough. So in this particular case, right, while deciding the case, 11 guidelines were issued. And court said that these guidelines will be applicable just like a law. Just like how these 3 rights are applicable, which are given in Constitution, same ways. These 11 guidelines also should be followed by the, police officers and all the different bodies keeping people in custody. Okay, is this part clear till here?
Yes, ma'am.
And a lot of these things, right, are included or are made a part of criminal law also. These are included as a part of criminal law. These are followed properly as well. Now, what are these 11 guidelines which were being mentioned? First of all, it was said that when a police officer is going to arrest a person, his police officers should have this name tag thing, right, above their pocket. Have you seen that?
Yes, ma'am.
So they should have their identification, name plus their designation should be clearly visibly written there, so that while they are going, it is very much clear. Okay. Plus, who is doing the interrogation? We would see, right? Police officers would go, they would beat the person, asking, tell, you have only committed the crime, who else were there? Right? So who is doing that interrogation? That thing needs to be maintained or written in a register. Okay, when a person is arrested, at what time he was arrested, who arrested the person, that should be written. When he is arrested, someone needs to put their signature, maybe from family member or maybe someone from the area where the person is arrested. Okay, he should be told that, okay, fine, you are being arrested. Now you can inform one of your friends, family member or relative to inform that you are being arrested. You have a right to inform someone that you are being arrested so that they can make arrangements for a lawyer, for your bail and all that stuff. Okay, where the person is arrested, those details should be given. The person should be informed about what rights he is having. Okay, when he is arrested, proper medical examination should be done, and that should continue in 48 hours, and records also should be kept. What is the condition of his health, right? Because if some custodial violence takes place, those also would be recorded, right? There are some physical injuries and all that stuff. So this is also very important. Person should be presented before magistrate, right? He should be allowed to consult a lawyer. Information regarding his arrest should be sent to the police control room, and all these points need to be followed whenever a person is taken in custody. Okay, apart from Article 22, all these things are also rights which are given to an arrested person by way of this case, DK Basu versus. This is a very important case. Okay, you can remember it. DK Basu versus State of West Bengal, 1996 case.
Okay, ma'am.